Item 1, pronouncement of judgment.
On the upper court, the appellant has failed to make out a case for interference with the judgment or order of the trial court. There is no merit. Appeal stands dismissed. Yes.
My lord, I beg to mention item number 41 and 42, my lord.
Item
41 and 42, my lord. Oh, sorry, my lord. Item number 4 and 5. My apologies, my lord. 4 and 5. My lord, this case is pending before the Supreme Court, my lord. This is an enforcement inspector in the transport department, my lord.
4 and 5.
My lord, the petitioners are aware of it, my lord. I've informed them also.
Who are for the
My lord, they are in the other court. I've already informed them. They are aware that this matter is pending before the Supreme Court, my lord. They are the one who have challenged, my lord.
So on earlier occasion also you made this.
My lord, yes, we have been submitting the same, my lord.
Okay. Just submitted by
4 and 5.
Ms. R. Corney, learned GA appearing with the respondents that the connected matter
My lord,
pending before the apex court.
yes, they are here, my lord. It's before the Supreme Court.
It's pending before the apex court, Your Lordship. It's pending before the apex court.
Just you say it is submitted by the Learned Council appearing for the parties. The connected matter pending before the apex court is set to be disposed of. Then paragraph. Just be in view of the submission. When shall we list it again?
My lord, after 4 weeks, my lord.
List the matter after 4 weeks. Yes.
My lord, item number 18, my lord.
Much obliged, Your Lordship.
Yes. Yes. What to do with item 18?
My lord, in item number 18, my lord, both the counsel, my lord, senior counsel, advocate general and additional advocate general are not available today, my lord.
Why? Because of this case, both of them they have left Shillong.
They are, Mr. Shula is not keeping well, my lord.
Yes, Mr. Jija.
I'm the petitioner.
No objection.
Next week, my lord. If
Next week, possible next week.
2 weeks.
Yes, sir, the request meet on behalf of the state respondents. This is matter after 2 weeks. This will. There are item 18 to
This is a connected matter.
18 to 27.
18 to 27. Outside. Yes.
May it please, Your Lordship. I beg to make a mention of part of the hearing, this item number 7 and 8, Your Lordship.
Yes.
Matter may be taken out after 1 week, Your Lordship, after 1 week.
What is this matter about, Mr.
This is
Abraham?
about pension matters, Lordship.
Pension matter.
Pension
Pending from 2021. Why?
They have some personal difficulties, Your Lordship.
Okay. No problem. So the request of.
Please, Your Lordship.
Just a minute.
Oh, sorry.
This is the request meet by Mr. H. Abraham, Learned G. appearing for the state respondents and not objected to by Mr. Upadhyay, Learned Council appearing for the petitioner. This is matter after 2 weeks. Yes.
Hello, bless Your Lordship.
May I please, Your Lordship. My lord, item number 16. In this item number 16, my lord, at least 5 of them were convicted by a common judgment. And 3 of them are already before my lord. And today is listed here in a connected matters, my lord. Now, my lord, Legal Service Authority has given me another 2 cases, my lord. Those who have not yet come before my lord. So those 2, my lord, I'll be filing in the next week, my lord. So what I was praying is, my lord, if this matter get taken up.
Those two, the new filing will be also in the same case.
Yes, in the same case, because it's all.
How many persons have been convicted here in this case?
Convicted, my lord, is 4 of them, I'm sorry.
So
Yes,
already 3 are before this court.
No, I'm sorry. 2 are before my lord already, and 2 are I'm filing in the coming week, my lord.
So it can be hard to get it.
Yes, my lord.
So we'll just this thing we cannot record this in submission.
Yes, my lord, yes.
We'll just on your request we'll just
2 weeks, my lord.
yes, on request made by Learning Council for the appellant. This is matter after 2 weeks.
2 weeks. Obliged.
May I please, Your Lordship?
Yeah.
Your Lordship, I beg to mention item number 9. I pray for some more time, Your Lordship. The senior counsel is having some personal difficulty. Item number 9, Your Lordship.
This matter was never heard, or it was heard at some length. No. Any objection? No objection.
No objection, Lordship.
2 weeks at the request of the petitioner. Yes.
Your Lordship.
May it please your lordship, I beg to mention item number 14, your lordship. The conducting counsel is out of station, lordship, due to some emergency. The matter may kindly come up after 2 weeks, your lordship.
This also 2 weeks. Oh. Yes. This will be on prayer made by. Yes.
Deeply obliged, your lordship.
May it please your lordship?
Yeah.
Lordship, I beg to mention item number 13, my lord, on behalf of Miss N.G. Sheila. She is on sanction leave, my lord. Can you have the matter after 2 weeks?
Who is the other side? please?
Concern on behalf of the party.
For the others.
No problem.
No objection.
This also 2 weeks.
Deeply obliged.
Lord, I'd like to mention item 12, my lord.
Yes.
And for the petitioner, my lord, some difficulty, I'm not able to prepare, my lord, today.
Is it quashing?
Yes, my lord.
Quashing.
Yes.
Yes. Any?
No objection.
This also 2 weeks. At the request of the petitioner. Yes.
My lordship.
Lordship, I beg to mention item 1 and 2, Lordship. 2 weeks time, Lordship.
Why? What happened?
Sugar Senior Counsel is out of station, Your Lordship. Bring for
This is a huge list of counsel here at the council.
Lordship.
Yeah. Yes. Other side?
No objection.
These are what? Service matters?
Lordship, no, Lordship. It's a eviction matter, Lordship.
1 and 2.
Yes, Lordship.
Both are connected.
Yes, Lordship. Both.
Then what is 153? There are, it seems that it is connected with WBC 152 and 153. 153 is not before us. No.
No, Lordship.
And just one prayer made on behalf of the petitioner. Not objected to by the Lord Council appearing for the respondents, appearing for the state respondents. This is matter after 2 weeks.
Please, Lordship, I'd like to mention item number 6. A brief next time.
Yes.
Brief 2 weeks time.
Item 6. Yes.
Lordship, I am for the private respondent.
Who is for contempt? No objection. No objection. You also same order. On the request of Swenson. Yes.
Yeah, please, Your Lordship. Your Lordship, I beg to mention item number 17, Your Lordship. Your Lordship, this matter may take up to 2 weeks, Your Lordship.
No objection. Okay. 17 also 2 weeks.
Highly obliged, Your Lordship.
May I please, Your Lordship? Your Lordship, I beg to mention item 10 and 11, Your Lordship. The conducting counsel, Mr. B. Bhatak, could not appear today, Your Lordship, due to some personal difficulties.
Yes.
No objection, Lordship.
When do you want it?
After 3 weeks, Your Lordship.
3 weeks.
Yes, Your Lordship. No objection, Lordship.
This was 10, 11, and the request made on behalf of Mr. B. Pathak. You record her name. Requested by so and so. Are you advocate record? No.
Yes, Your Lordship.
In this case?
Yes, Your Lordship.
And then you don't have to resign anything, just read 36. Aspirate for my P3.
Yes, Your Lordship.
I'm very poor in remembering name. Now I consult for the petitioner. Yes, this matter.
Deeply obliged, Your Lordship.
10, 11, both same.
Please, Your Lordship, I beg to mention item number 3. Your Lordship, I pray for 2 weeks' time. The conducting counsel is on leave, Your Lordship.
Yes, was this matter which was pending for compromise?
Yes, Your Lordship.
4 years. Yes. No objection. As put forward by the learned counsel of the petitioner. No object, not objected by the learned state counsel appearing for the respondents. This matter after. After
2 weeks, Asha.
okay. Objection.
Item number 15.
This is the only item.
May I please, Your Lordship? Your Lordship, in this matter, the conducting counsel is appearing in courtroom 3, Your Lordship.
So what
I
is to be
replied
done?
that this matter may take up at the end of the board, Your Lordship.
This is the only one matter, sir.
Your Lordship. He's on his legs, Your Lordship.
What is to be done? Somebody else has to start then.
Lordship.
You start.
Lordship, I have not prepared this matter, Your Lordship.
If you have the file, let us point out what is there, what is there. Otherwise, this court cannot be, tell somebody else. Yes, Mr. Sheikh. Yes, please.
May I please, Your Lordship? Lordship, the conducting counsel, Sir Khan, is on his leg. Kindly take up the matter end of the board, Your Lordship.
That is what has been said. There is only one matter left now.
Okay.
Yes, Mr. Nandi, you are challenging maintainability of this case.
Maintainability on the last occasion, I also pray that let it be heard on merit also. So accordingly, this has been.
So you are not maintainability anymore. No, first, if you have the maintainability part, see, you go to merits.
My lord.
Once we see that maybe the ground of maintainability is not that strong. But then if we decide the matter on maintainability and
I relied on that authority of the Honorable Apex Court that I have already provided. I relied on that.
That is the only thing.
Yes.
There is no other.
Yes. And that Himachal Pradesh High Court also, Your Honor, Lordship decided that there are in the Himachal Pradesh High Court seat that it is to be decided in some of the parts. So then I stand by on this, both these authorities.
There is nothing to add.
Yes.
What was the decision you relied upon earlier?
Earlier, that is Honorable Apex Court. That is in Virudnagar Hindu Nagardal Dharma versus Tutti
It is not reported anywhere. It is reported.
It is in Supreme Court.
No, that is okay. It is reported in which journal?
Is reported the Supreme Court cases. It is.
Has it been reported in SCC?
Yes, it is in SCC also. It is.
What is the
2019 Volume 9 SSC 538.
What is the paragraph you were referring?
Paragraph is 14.
Paragraph 14.
14.
Now, this submission of yours would be dependent upon the fact if you can establish before the court that yes, the order which is under challenge was appealable. It is only on that. Now, how do you say that order was appealable? The impugn order is appealable.
My lord, the impugn order is appealable because the very authorities, there is no provision for this thing, CRP, that they have come up. The petitioner side has come up with CRP. There is no provision. And they have
that means you want to say the impugn order is unassailable. It cannot be challenged before any court.
No, that there is, I got the authorities of that the misappeal can be preferred before the Honorable High Court. But as Lordship said that the very reference is required where it is reported.
If you say appeal can be filed, that means it has to come as second appeal, is it?
Second appeal.
Now, if you take into consideration the language of section 100, second appeal is under section 100 CPC.
100 CPC.
Now, it speaks about decree by, it is against a decree, isn't it?
My lord.
So this order, in the interim order is not a decree, isn't it?
No, it is not a decree.
But then?
It is an order.
Yes.
This is the appellate court's order. And here it says that as I read out that on the last occasion regarding
Section 108 or one section 108.
Yes, 108. Lordship said that it is a procedure.
See, that is by the language. You see, if I am wrong, then you have to correct me. And how do you correct me? That is what is appeal. See, if you see the procedure and appeal from appellate decrees and orders.
Yes,
decrees
and orders.
Orders. Now, so if you say that appeal lies under second appeal lies under section 100, section 100 takes into consideration only decrees, not orders. Isn't it? Now, if you see here, 108 says procedures.
Procedure.
Then where is the power? Where is the power? Where is the, like section 100, it specifically says that second appeal lie in decrees. Okay, but then where you show the provision under which second appeal can be filed in orders also. Not considering this thing, decrease, only decrease.
Lordship is that I relied on this very particular provisions that section 108 as it stated that it lies that relating to the appeals from the appellate this thing B, the orders made under this code or under any special or local law in different procedure is not, that is the provision that I rely on. Section 108.
You are relying on, but then explain it to us. You are saying it's a relying on. See, what I just say, just read 108.
That the provisions, the procedure in appeals from appellate decrees and orders. The provision of this part relating to the appeals from original decrees shall, as far as may be applied to appeals. Appeals from A is appeal from appellate decrees and B from orders made under this code.
Under this code.
Under this code.
So under this code, under what provision a second appeal from orders is maintainable? That is what the question.
So far as the second appeal is concerned.
Yes, against orders.
Against this order.
Now, so far as decrees, we understand section 100 is there. But then for orders, where it is there?
Because so far as this is concerned, my lord, that it provides only in these things, section 108 as I have read out. And moreover, that so far as the order 43 rule 1R, it says that where the injunction application is rejected, then also the appeal lies. I got the authorities there that the the miscellaneous appeal lies. But as Lordship said that where it is reported, I could not get those
No, no, you have to
reporting.
show us. This court is not expert in civil matters. So you have to show.
And that is why
See,
on the last
you are talking about Order 43 Rule 1R.
Rule 1 where it says
Yes,
that
that is an
injunction
injunction
is,
order. Appeal from injunction order.
yes.
Come, let us see Order 43 Rule 1R.
Order 43 Rule 1R. An order under Rule 1 or Rule 2, Rule 2A, Rule 24, Rule 10 of Order 39. Where it is the injunction is rejected. Even if it is rejected, then also the appeal is to be.
No, but then you have to just say it. You have to clarify it. If that is your stand, how come you take a stand and say that this is...
And very CRP is against the judgment and order. The state that now my respectful submission is that before your lordship is that where is the, because their claim that they obtained the order of injunction in respect of Patta number 514, Dag number 740. Where there
No,
is
you are going to merit. Just wait.
Yes.
Just wait. Just hold on for a second. Because Mr. Khan is yet to address this court on merit.
Let my
No, but then let us clarify that part of this. About this appeal. You cannot leave it half-hearted.
My lord.
This order of the appellate court, which is under challenge here, will it come under Order 43 Rule 1R?
My lord, yes, it says that where the injunction is allowed or rejected, here the injunction has been rejected.
See, whether it would apply only in case where rejection is by the trial court,
my lord,
or by the appellate court.
My lord, so far as this order 43, it says that the appeals from orders, an appeal shall lie from the following orders under the provisions of section 104, as it is mentioned in order 43, rule 1 R.
Now here it's a case, this revision is against order passed by appellate court, isn't it?
Yes, that they have preferred that it is under 227 of CRP, of the Constitution.
This court is asking me a question that whether the order passed by the appellate court can be construed as an order passed under Order 43 Rule 1.
My lord.
So can it be termed as order?
My lord. This so far
it means if any injunction order passed by the trial court, this also will come under Order 43 Rule 1, and by the appellate court also will fall under Order 43 Rule 1.
Yes.
Oh, on what basis you say it? Anything to show?
My lord, as I have respectfully submitted, I got this that the miscellaneous appeal shall lie, but there is no authorities, because on the last occasion, Lordship was pleased to impressed on the point that where is the authority? Because there are
exactly because this court has no knowledge about that part. So definitely court is looking for from you. Since you have raised that plea, it is for you to show.
That is, my lord, what I have submitted. I have placed the authorities also that 227 application has got no part to play in this. Now it is up to the.
It is your submission will be entertained only when you can clarify this court that this order 43 rule 1R will apply in case of first appeal as well as in second appeal.
Because there are two things, my
So
lord.
section 100 will not come here. It has to be under order 43 rule 1R read with section 104.
104.
Isn't it?
Yes.
So specifically says that the appeal will lie from these orders which are specified there, but there are no other orders. Isn't it? Now to satisfy this court as to the fact that this order impugned is an order falling under order 43 rule R, that is what you have to show.
My lord, whatever I have already placed before the lordship.
You have not placed anything with regard to this. So far as the query of the court is concerned, you have not placed anything.
My lord, that in that case, that the authority, because as I have
The decision which you say you have placed before this court is only with regard to the fact that application under 227 will not be entertained where their recourse is prescribed in the civil law.
Yes.
That is what.
That is.
So if you say about this, then that is court is asking you about what is the recourse. Now your response is that second appeal.
Yes.
Now second appeal would come under what provision? Okay.
Now,
In an injunction matter, the second
appeal against order. That is. That, yes, lordship is correct so far as that.
court is not correct. Court is asking you query. Court does not know anything. Try to understand.
My lord, it is my respectful submission is that as I have placed the same thing, I do not mean repeat. Let my learned friend to
You
satisfy.
have not clarified. This court wants to know whether this order 43 rule 1R will apply in case of first appeal, also as well second appeal or not. That is the main thing. Or there will be change in the factual scenario.
Because I got the authority so far as I got it, but those are not the reported thing I did not get. That is why I have not placed those. Though in some of these, they said that no, it is only the miscellaneous appeal shall lie before the lordship of High Court. But regarding that, the specific that where it is reported, I didn't get. That is why I could not place it.
No, Bhajan,
No,
if you say something on the proposition, where you saw those proposition? Where?
in the net money.
In the net, and you do not know
Because
where it is.
lordship on the last occasion said that somewhere some court was misguided by that.
No, but then that is up to you to verify. But then first, if you have something, you should place it. Then we will see whether authentic or not. We can verify.
My lord,
If you know the party's name, then we can go and you can see the.
my lord, that is why my respectful submission is that my learned friend has come up with this CRP under 227. Let my learned friend to submit that how he has.
You have
come.
challenged the maintainability, isn't it?
I have challenged and I have whatever I have challenged.
Once
I
you
have
challenge the
placed.
maintainability, that so far as the question of maintainability is concerned, that is for you to establish.
That is.
And once, if you say that you are giving up that plea, then we will tell him to address the court.
Let it be heard then on merit because.
So we will say the plea of maintainability has been surrendered. You have to give it.
Let my learned friend to submit on merit. I am ready for this hearing.
So one hurdle is gone for you, Mr. Khan. Yes.
Now should we come to the impugn order?
Now, Mr. Khan, you did a revision, why it is under 227? Even if we assume, of course we are not very sure, this court is not very sure, that no second appeal lies. Mr. Nandi may be correct. You see, but then the confusion remained, so he could not clarify. Now, if you say that if no second appeal lies, then is there any remedy prescribed in CPC?
No, Lordship.
Why?
That is exactly the issue. No, there is no remedy.
No, but then High Court has the power of revision then, under 115.
Lordship, High Court has got the power under 115, but 115 will not be applicable here.
Why?
Because this is a case where the
Interlocutory order.
there are hurdles, Your Lordship. With unnecessary, same argument will have to come.
No, but then the thing is that the court does not commit a mistake by this thing, because this, though Mr. Nandi has raised that point, but the thing is,
Lordship, can you recollect? Unfortunately, he has not given me the copy of the judgment, though the court had insisted him. I just don't know the reason why he is not giving.
that decision, the apex court is.
Yes, he has not given me the judgment.
Mr. Nandi, you have not served him a copy of the judgment in that.
No, he has not given, because
No, I have on the before last occasion, I have this thing, I have informed them that what judgment I am relying. I did it.
You should have given him a copy. What is the problem?
Court insisted that today also my junior asked them and he.
No, normally here it is
Who has
exchange.
asked? Please clarify. Who has asked?
This is very unfortunate. I don't know why.
You supply him a copy.
Because the query.
We'll ask for some clarification, Mr. Khan. Even though because this court
Because the query lies in that particular judgment, the paragraph which we stopped in the last date. You
just supply him a copy of this thing.
Okay.
Then we'll take up matter.
And my lord, we have already sent this thing also. This authority, what we are relaying, already sent to my learned friend.
Text WhatsApp.
The junior is saying he sent the text after the court's query, he is sending it just now. I just don't understand what level of.
How? Which manner?
WhatsApp?
Why you cannot even make a copy, extra copy of this?
No, extra copy we tried here, but in the morning.
You cannot Xerox it. No, you should Xerox it then first, and then you are not supposed to prepare it only on this morning. It is not that you could have done it previous day. This is what kind of explanation it is.
And I also don't understand what type of practice they are trying to bring to this High Court.
No, this is not very fair. You see, whatever you want to rely on.
Lordship had said the other day, kindly given the copy, he took my number, and today also I was expecting a judgment on that.
Please exchange your things also, Mr. Khan. Whatever decision you want to rely.
I'm just relying on that 227 because we have yet to go to the merit. I'm relying on the same judgment because Lordship, what happened the last occasion, Lordship read out the operative part of 227, and then Lordship said 227 will be operational only if there is a certain facts. The condition is there in that particular paragraph of the judgment. Unfortunately, Lordship, until unless I go through the relevant paragraph, I won't be able to assess the court. The same judgment which is relying. On satisfaction of those particular facts, then the court will assume whether 227 will lie or not. So once we address that issue, then I have to go to the merit. And then we get the guideline, the query following from the court whether why 227. I'll answer it from his judgment on that paragraph. For that I have to go to the merit part. What is the ground whether they satisfy the need of the court? If I can't satisfy your Lordship, then Lordship will put a query to me. But we are yet to overcome that hurdle. He has not been able to satisfy the court and he has taken 3 days for that. Today on the issue of 227, the same judgment which is relying, he has chosen not to give it to me. And then what's
something not very welcome.
Very unfortunate. In the High Court level, Lordship, what is my learned friend trying to prove? That judgment supports everybody.
My lord, so that I am providing this my copy to my learned friend.
No, that is not the issue.
It is up to you what you do. I have exchange of things. You see, like should not be something like that. You see, an effort is there to obtain order behind the back of a party. This is something not very. This court doesn't appreciate this. This is something this court will never encourage. Will never appreciate it. You're fine in the courtroom. Why? You give them all the things. Whatever ammunition you rely upon,
my lord, you should. All the authorities that I rely all are to be provided to my learned friend.
You give at least you give him a list then.
Okay.
You give him a list. If it is bulky, definitely we will not say. We will not drag you to make incur some expenditure for facility. But then if it is a small thing,
just one
maybe 5, 10, 20 rupees you can always pay, isn't it?
No.
That is one thing. If you have many, give him at least provide him a list.
Okay.
And similarly, Mr. Khan is also.
Yes, we are duty bound.
Counsel assisting Mr. Khan will also be doing that.
Then
we do that first and then we come for it.
that, my lord, there will be no hearing, any further hearing for today, till we provide these copies. Till we provide the copies.
Is there any purpose of providing it after hearing is completed?
No.
Then.
That is.
It's up to you. If you want to proceed without any citing any law, we will proceed. What is there? The court has the whole day with it. There is no problem in it.
No. I do not mean that it should not create any inconvenience to any other.
The question is not of causing inconvenience. If you are, thinking of relying upon some decisions, then this court would expect that those things are supplied in advance to Mr. Khan, so that he gets a chance to go through it and give appropriate reply. Similarly, if Mr. Khan relies on something, he will give it to you so that you can go through it, give a reply. The question of law managing may come up, isn't it? You also need to respond. So that is what. It helps parties to prepare their case better. And it is quite normal here.
It's very normal practice.
High Court hearing, you will not find that this kind of thing comes when
No, never happened. That's why I'm surprised.
Counsel stands up and says that authority relied by you is not supplied.
Right from the first day, Lordship, not previous day. Previous to previous day also, I asked a copy. He didn't give. He ran away from the court. Very unfortunate. I'm telling him in his face.
Very unusual.
Very unusual. I don't know from which High Court he comes. What is the level of practice he does there?
No. My learned friend is talking too much.
It's okay. No, it's not about too much. This is a fact. It's not about too much. Mr. Counsel, please, I'm telling the facts. No. You ran away from the court without giving the copy. That's very unfortunate.
Do not have your personal exchanges.
It's not about this is a fact. Don't do that. You ran away from the court.
Anyway, enough is enough. You do not.
We don't make such statement in the court, Lordship. But he did.
Anyway, please hold on.
Lordship can adjourn the matter. Next day we'll take up some other date. And can you give me the citation?
Anyway, you will supply him.
I will provide the list of the citations to my learned friend.
Before this matter is taken up next date.
Yes.
Next, my lord, if a date is fixed.
Mr. Khan, you also supply him so that he doesn't get a chance.
No, absolutely, Lordship.
Yes. Counsel for the parties. Shall exchange the list of authorities sought to be relied upon by them before this matter proceed for final disposal. Before this matter is taken up for final disposal. When should we wait?
Let it be in the first week of June. Any date may be fixed.
I'm here. No issue.
Just wait for. This is matter after 4 weeks. This is June. Oh, this is today. 4 weeks. Make it like this so that it goes to the first week of June. 4 weeks. Place it in the first week of June, so that it's not going to be. Okay. Yes, please for the parties.
Lordship, the interim order till next date. There's an interim order.
My lord,
yes.
So far as this interim order, it is an agricultural, and my livelihood depends on it. So
let us have it next week then. Hearing.
Beg pardon.
Let us have a hearing in the next week then.
Because I am to cultivate it.
That is okay. So that is why then if there is urgency, let it be disposed of in urgent matter then.
Because this month I am not in a position to.
So that is the problem, you see.
That is my hardship I have
experienced. You are worried about your transfer affair. Again, you are not ready to spare your valuable time. How can it be? The interim order past order shall continue till the next date. It is given the option. You cannot say this way or that way. Say either one. If you say that this is urgent matter, then we will accommodate you next week. We will hear you next week, if you want.
Next week possible.
Yes. After 4 weeks, the first month of June.